Well, hello, everyone. Welcome back to another one of our virtual events. First, I want to say thank you for those of you who are part of the Apriem family who are attending again. And for those of you who are joining us for the first time, we're so happy to have you. This will actually be the last virtual event for us for this year. The title of today's event is Planning Ahead, Preparing for the Loss of a Loved One. My name is Josh Garland. I'll be the host for today's event. Now, we have an hour total scheduled for today, which means that we'll probably have about 45 minutes or so of presentation time, followed with, let's say, 10 to 15 minutes of questions. With that, I'd like to go ahead and introduce today's panelist speaker, which is Tiffany K. Chiu. She's the owner and founder of Chiu Law. She's been practicing for over 10 years, representing clients in various life stages with all different levels of wealth. Now, Tiffany's breadth of experience gives her a unique and well-rounded perspective on the scenarios her clients encounter when creating their own estate plans. Now, we've partnered with Tiffany for a really, really long time, and we're very excited to have her back.
Thanks so much, Josh. It is always such a pleasure to be here with Apriem and my Apriem family. And just thank you for taking the time in your afternoon to join us and on this, what I consider a really important topic. Today, we're just going to, like Josh said, talk about how to prepare for the loss of a loved one. And this subject in particular is very close to my heart. Earlier this year, I did lose my father. And I did feel that if we had the burden of administration afterwards, or trying to get everything done before, my dad actually passed, it would have been so much harder because what we wanted to do was spend time with my dad before he passed. And so my hope and my encouragement for everyone today is to have something in place. I had some time before my dad passed to prepare. My mom did as well, but I know a lot of times we don't have that time. We don't know when something is going to happen. So my hope is for us to all be prepared for anything, and that you may not be at this webinar because you anticipate the loss of a loved one now, but hopefully you'll find some information here that would be helpful for you to understand what your loved ones might have to go through if anything were to happen to you. And hopefully we'll be able to help you get everything together so that it'll be an efficient process should anything ever happen. So this is really just a seminar, not just for anyone, again, who is preparing for the loss of a loved one, but for anyone who really wants to get their estate plan together because they want to make sure that their loved ones are taken care of. So I just wanted to start off with a quote that I found that was so appropriate for what we're going to talk about today. And it was from Abraham Lincoln, and it says, "Give me 6 hours to chop down a tree, and I will spend the first 4 sharpening the axe." And that's what we're doing now. Is what we want to do is spend some time sharpening the axe and making sure that it's nice and ready to do the tasks that are inevitably waiting for us. And if we were to spend some time to do that, then we don't need to go through the burden and the cost of a post-death administration, meaning taking care of tasks that need to be done after someone passes away in the middle of having to grieve that person as well. So we want to just make sure that everything is in place. And in order to understand what needs to be done or to prepare for the loss of a loved one, what we really need to start with is to understand what needs to happen when someone passes away. So with that, I'm just going to go into post-death administration. And post-death administration is referring to the process of carrying out someone's wishes when someone actually memorializes them in estate planning documents. It refers to tasks that just need to be completed just by law. It refers to notifying people. It just refers generally to the things that need to be taken care of with the ultimate goal of distributing assets to the people that it should ultimately go to. And post-death administration can come in 2 forms. And the first one could be a probate administration, where if people didn't have, or someone did not have documents, estate planning documents prepared ahead of time, like a living trust, then we might have to go through a process called probate, where a court has to get involved and help us through the tasks that need to be taken care of in an administration. The other type of post-death administration that I often get involved in is called the trust administration. And this is a situation where someone has prepared an estate plan, they have a living trust in place, they properly funded that trust, meaning transferred items, assets into this trust, and they're properly titled in the name of the trust. And when we do that, then we have to just go through the process of carrying out the terms of the trust, and we call that trust administration. In this webinar, I do want to emphasize that trust administration is far simpler, more efficient, both cost-wise and time-wise than a probate administration. So, and there is just that work of sharpening the axe would include getting a trust together, having your assets looked at to make sure they're properly titled, so that the actual act of cutting down the tree and taking care of post-death administration is a lot easier and more efficient. So in post-death administration, there are just several tasks that need to be taken care of. Some of these are because it's imposed by law, and some of them are just practical things that need to be taken care of. That includes notifying appropriate individuals and entities. If anything happens to someone, government agencies need to be notified, credit reporting agencies should be notified, creditors, heirs, and beneficiaries, and we'll go into this in more detail. The other task that should be taken care of, we need to marshal and inventory and appraise assets that the decedent left. So everything that the decedent owned needs to be collected, because we need to make sure that they're transferred over to living people, their beneficiaries, or their heirs at law. And so part of post-death administration, a large part of post-death administration, includes collecting all the assets, locating them, putting someone in charge of them while we go through the administration process, paying off debts, and then finally distributing these assets to beneficiaries. And the next task that we need to take care of in an administration is settling all legitimate claims. There will be creditors making sure that your last credit card debts are paid, mortgage payments are made, any of these legitimate claims, debts that you legitimately incurred during your lifetime, they will have to be paid. And then we'll have to file some tax returns. You can't avoid taxes. And of course, that includes after you pass away, tax returns need to be filed. So we'll talk about the final income tax returns and estate tax returns that possibly also might need to be filed. And the whole goal of a post-death administration, whether it's through probate or through a trust administration, is eventually to transfer everything that a decedent owned that was in his or her name or in the name of the trust to the beneficiaries that the decedent listed in a testamentary document, like a will or a trust, or to eventually transfer it to their heirs at law. So if someone did not prepare these documents, California law already has a hierarchy of heirs that would inherit for if the decedent passed away. So eventually the assets in a probate administration would eventually be transferred over to those heirs. So in a post-death administration, the first task that we need to do is make sure that people know that someone passed away. Government agencies that need to be notified are generally the Department of Healthcare Services in California, the Franchise Tax Board, Social Security Administration. The Social Security Administration is oftentimes taken care of or notified. If someone passed away in a hospital, they're often notified by the hospital. People, especially if you're receiving Social Security payments, they have to be stopped. And if you receive a payment or if a decedent has a check issued to them from the Social Security Administration after they pass away, that check is going to have to be returned to the Social Security Administration. So we need to notify them to make sure that checks are cease to be sent over to the decedent. You need to notify the Franchise Tax Board. California wants to make sure that all taxes that are due to them will be paid. And so we need to notify them, and they'll issue a statement saying that you do or don't owe any taxes. And the Department of Healthcare Services also needs to be notified that someone passed away in California. So those are some government agencies that need to be notified. And after someone passes away, it's really helpful to also notify credit reporting agencies. So the three big ones are Apriem, TransUnion, Equifax, and this is actually a very practical consideration. Oftentimes when people come into my office after maybe a year and a half, after someone passes away, they come with a stack of papers, maybe some wills, and trust documents, maybe some estate planning documents. They also come with some statements and evidencing title, but sometimes they'll also come with an invoice for fees incurred after a decedent passed away. And I remember the last one was from Verizon. Because what happens is someone will try to steal the identity of a decedent and use their social security number to open a Verizon account and or even try to buy a car. And if these credit reporting agencies are notified that someone passed away, then they would stop that transaction, nip it in the bud. But if we don't notify them, then inevitably someone is going to try and use their social security number for their own unscrupulous gain. So that's just a practical consideration that we make sure that we take care of when someone passes away. We want to notify creditors. We let the credit card companies know, pay them. Anyone who has those legitimate claims need to be paid. And by law, we need to notify heirs and beneficiaries. So heirs are people, the difference between an heir and a beneficiary. An heir is if you don't have any estate planning documents and you don't list anyone you want to receive your assets. And if you don't, then California law will provide who will receive them, and they're called your heirs. By contrast, beneficiaries are people that you actually do list as people that you want to receive your assets should you pass away. And so we do need to notify them, because once someone passes away, and if they do have an entitlement to the assets that you left, if they were left something in your trust or in your will, or if they are your heir, now they have an interest in this post-death administration, and they want to make sure that whoever is in charge of this administration is doing their job. So we need to notify them to let them know someone passed away and that they might have an interest in the decedent's estate or the decedent's trust. And so then we're kept accountable as the person in charge of the administration. We're kept accountable to these people to make sure everything is taken care of in the most cost-efficient manner, as well as the most expeditious manner. So the next thing in post-death administration is marshaling and inventorying and appraising assets. So the whole goal, again, of administration is to make sure that we distribute a decedent's assets to living people. We want to make sure a home that a decedent left is now transferred over to someone who is living. So part of post-death administration will include this marshaling and inventory and appraisal of assets. And these assets will include everything that the decedent ever owned at the time of his death. That'll include real property, cars, vehicles, automobiles, bank accounts, whether they're non-retirement accounts or retirement accounts, checking, savings, CD accounts, anything that an institution, financial institution would have. Personal property, people have an interest. Those beneficiaries want their, diamond rings from their mom. So we want to make sure that we marshal those and take charge of them before it's ultimately distributed to the beneficiary. Business interests, those often are subject to agreements like buy-sell agreements, and we want to make sure, again, that we take that into account when we do this administration. It's something that is of value, something that the beneficiaries want to make sure that they get their share of. And we also want to make sure that we take into consideration life insurance policies, these payable on death accounts, in case any proceeds are due to either the trust or beneficiaries after someone passes away. So in post-death administration, we need to marshal, inventory, appraise assets. We also need to settle all legitimate claims. When someone passes away, their debts do not get extinguished, and their debts do not get inherited by living people, generally speaking. I often get questions about that. I'm worried about my dad. He had a lot of debts. What ends up happening is that those debts are paid through his estate. If there's nothing, then they have to be negotiated or extinguished in some way. So we need to settle all those claims before we distribute anything to the beneficiaries. And those include credit card debts, student loans, mortgage payments, business loans, any of these claims that the decedent incurred while he or she was alive need to be paid and settled. And then we have to file those income tax or those tax returns. So income tax returns are due April 15th of every year. And so we will need to file the final income tax returns for the decedent. And we need to mark them final to make sure that the federal government knows not to expect another income tax return from this particular social security number. Estate tax returns may or may not need to be filed. These will be dependent on the size of your estate, who passed away, whether it's the first spouse, whether there is an estate tax issue, but that should be discussed with your CPA and with an attorney, and really both professionals are really helpful in this situation. I've come across situations where CPAs don't even understand why a 706 and estate tax return should be filed. And so it's really helpful to have an attorney explain that, or vice versa. Maybe the attorney doesn't understand why a 706 should be filed, and the CPA can explain all the tax benefits. And it may not be the tax benefits that your surviving spouse may appreciate. It's actually maybe something that if you have children, when your assets eventually pass to your children, if you file an estate tax return, they may incur less taxes. So it's really important to consult with professionals to see whether or not these tax returns should be filed. They're not easy tasks. It does cost a little bit of money. It does take time to gather all the information necessary for these returns, but they're definitely worth it for eventually for your future beneficiaries. So that is also needing to be done in a post-death administration. And again, the goal of the administration is to make sure that assets of a decedent are eventually transferred to the heirs or the beneficiaries, and to living people who can now enjoy the home or the accounts that the decedent left. So now that we understand what is involved in a post-death administration, how do we prepare now? And I think key to preparing now is to make lists. And it's really helpful. I mean, as we went over the post-death administration, I'll kind of explain why these lists are important, but it's helpful to prepare the people who are going to take charge of your estate or of your trust to have these lists for things that they need to take into consideration, or a list of team members that can help with the administration. So I think the key to preparing now is to have a list, and the lists that I would encourage my clients to make are lists of assets, list of your debts and expenses, and lists of contact information for people that they can talk to and who understand your financial situation well enough to help the administration process. When we were going through the list of post-death administration, we include this notifying of appropriate entities, legitimate claims, and filing tax returns. But we also talked about marshaling, inventorying, and appraising assets, and all with the goal of distributing these remaining assets to the beneficiaries. So the first list is a list of assets. We need to make sure that whoever is going to take charge of the post-death administration understands what they need to locate. So what marshaling refers to, when I hear marshal, I think of someone who is like wearing a uniform and they're like taking charge of something, and that's essentially what it is. When you marshal assets, what you're charged with is the task of locating assets. So locating whatever a decedent owned, whether it's here in California, whether it's out of state, even outside of the state, outside of the country, even though we can only take care of assets that are in the United States. But it's important for someone to consider assets, worldwide assets, because that will affect tax returns. But this person, usually referred to as a personal representative if a probate administration is involved, or a trustee if a trust administration is involved. The person who's in charge of the administration will have to marshal and locate all of these assets. And now this personal representative or trustee is charged with the task of making sure that these assets are maintained through the administration. Because again, if our goal of administration is to distribute the remaining assets to the beneficiaries now have a vested interest in making sure that whatever they're going to eventually receive is not going to be wasted through this administration process. So the trustee, the personal representative, are now charged with the task of locating these assets and maintaining them. If there is a property involved, we want to make sure that we pay the mortgage payments, that's not going to go into foreclosure. We want to make sure that gardening is taken care of, that it's still going to be in marketable kind of a situation or circumstance, or condition, a marketable condition. So that's the first task, is to marshal. And then we need to inventory. So if a probate administration is involved, what inventory means is giving a list of all these assets to the probate court. If it's a trust administration, what we need to do is an accounting to all the beneficiaries. So again, the beneficiaries have an interest in understanding what assets are eventually going to be passed to them. So what helps is to give them a list of that and to keep account of how we use these assets through the administration process, to make sure that there's no argument about what eventually passes to them. And the next thing we need to do with the assets, we need to appraise them. So again, the beneficiaries want to know that if we're going to give them $100,000, it should have been $150,000. And the way that we do that is to have a third party appraise these assets and say, okay, this is how much it was worth at the time the decedent passed away. And if you're entitled to half of it, then you're entitled to this amount that a third party has determined to be the fair market value. So those tasks need to be taken care of. So it's really important to have a list of assets so that your trustee or your personal representative is able to locate, at least they have a starting point to locate all the assets that the decedent has. And again, the goal is to distribute all the remaining assets to the beneficiaries. So that list will be super helpful in administration. Let's see. And again, when we talk about the assets, we're talking about everything that the decedent owned, whether it's real property, bank accounts, vehicles, life insurance policies, guns, business interests, cryptocurrency. All these things need to be made, a list needs to be made for these assets. And what's also important while we're marshaling and inventorying these assets, we need to collect evidences of title. So for real property, what we're trying to collect are deeds. For bank accounts, we're trying to collect statements. For cars, pink slips, we also might need life insurance policies, share certificates, or membership interest certificates for companies or corporations, and notes that might evidence who owes me money or who owes anybody money. And those are really important. And actually, this is what determines whether or not your post-death administration is going to have to go through probate, or if we can get everything done through a trust outside of a court, outside of the expense and the time it would take to go through court. So the key, so what we're doing is now not only making a list of these assets, but collecting evidences of title. And as I said, the evidence of title will tell us which kind of administration we're going to go through, probate or trust. And so all of your assets, if you're a client of mine, if we've worked on estate planning ever before, if you attended the last webinar I do, I just think this is a great framework for people to understand how their assets should be looked at, because it'll help understand whether or not your heirs and beneficiaries will have to go through the cumbersome task of a probate administration. So all of your assets, or all of a decedent's assets, will fit into one of these 4 buckets, and which bucket they fit into will be dependent on these evidences of title that we had previously discussed. And so the first bucket is the trust bucket. The second is a payable on death bucket. The third is a joint tenancy bucket. And the last bucket's the probate bucket. And depending on the bucket that the asset is in, that will dictate who is going to get your asset and whether it's going to go through the probate administration. So which bucket your asset is in is going to help us determine how it's going to be distributed to the beneficiaries. So the probate bucket is going to have assets that are just in the decedent's name. So if it's only in John Doe's name and it doesn't have a beneficiary listed, then it is in this probate bucket. And what that means is that upon a decedent's passing, it's going to have to go through this court process where a court is going to have to step in and supervise that distribution and supervise the whole post-death administration, and eventually passing on all the assets to the beneficiaries. And in this process, I don't know how many people are familiar with probate, but it's generally a very expensive process. It's generally also very time consuming. I hear in Orange County right now, it's about 1.5 years. I would imagine in LA, it's going to be 2 years for a simple administration. It's just a long time and it's unnecessary. Really, if we do this sharpening of the axe beforehand, if we do all this preparation beforehand, then your loved ones aren't going to have to go through a probate administration. So we don't want assets in this bucket. We don't want to leave anything in just John Doe's name without a beneficiary. Oftentimes couples will have assets that start in this joint tenancy bucket, and usually that would be their house, maybe some bank accounts where they own with their spouse or with someone else. And if your asset is in this bucket, what that means is that at least 2 people are on title. And when one person passes away, when you hold something as a joint tenant, you're expressing your intention that you want your other joint tenant to automatically assume ownership of the entire asset. So when assets are in this bucket, it doesn't go through a probate proceeding or a probate administration when one person passes. But when that survivor is the only one on title, this joint tenancy asset is no longer in this bucket. It's now in this probate administration bucket. And when the surviving joint tenant passes away, it'll go through probate. So generally speaking, one of our goals when my clients come to me to update their estate plan, we want to try to keep assets out of their joint tenancy bucket because we don't know if they're going to forget to transfer it out of this probate bucket when one person passes away, or we don't know if something's going to happen to both joint tenants at the same time, in which case it'll go through probate. And in this whole process, one of the things I want to emphasize, and I hope you're kind of getting it's coming across, is that we don't want to go through a probate administration. We will always have to go through some kind of a post-death administration. We're trying to avoid the probate one, and we're hoping to stick with the trust administration. And by doing all of these tasks ahead of time and having this preparation completed, then we are going to eventually, hopefully, avoid this probate administration. So we don't want assets in this joint tenancy bucket generally. Instead, we want everything that we have to be in this trust bucket. And if your statements or if your deed or if your pink slip or anything that evidences title, if it reflects that ownership of that item is in this trust, then it should say something like John Doe, trustee of the Doe family trust. And when that evidence of ownership reflects title in that way, then that asset is in this trust bucket. So for instance, a property might have started off in John Doe and Jane Doe's name, husband and wife as joint tenants, which means that it started off in this bucket. But after going through an estate planning process and having a living trust prepared, maybe the deed is updated to reflect title as John Doe and Jane Doe, trustees of the Doe family trust. And again, when the deed reflects title in that way, it's subject to this trust bucket. And that's the goal oftentimes when I work with clients, is to keep things in this bucket and away from these two buckets here. And when it's in this bucket, instead of having a court get involved to do the administration process, we have that person called that trustee who we trust to take care of the administration and eventually transfer everything that we have in this bucket over to our beneficiaries. And the last bucket is this payable on death bucket, which generally includes things like life insurance policies, 401ks, and IRAs. They're still titled the evidence of ownership, the statement, the life insurance policy statement, the retirement account statement. They reflect ownership in one person's name, John Doe's name, Jane Doe's name. But the difference between this bucket and the probate bucket is that for assets in this bucket, there's a beneficiary listed on that particular account or that life insurance policy. And so it avoids probate because those beneficiaries are then on file with the institution, whether it's a life insurance company or whether it's that a financial institution. And so then they are charged, this bank or this life insurance company is then charged with transferring these assets over to the beneficiaries and having those be distributed to the appropriate people. So again, in the post-death administration, a key to doing an efficient administration is making a list. And the first list that we want to make is of assets. And when we make a list of those assets, one of those things that we want to do is collect all evidences of ownership, deeds, statements, life insurance policies, pink slips, business interest, share certificates, all of those things so that we understand which bucket that particular asset is in. And when we understand what it's in, we can try to avoid, or we can do what we need to do to avoid this probate bucket. And we can retitle assets or update title to assets to keep them in these first two buckets, which will avoid this cumbersome process over here. Okay, if you're a client of mine, I have a way of making a list of your assets. And if you work with us, what happens is we send you an intake form and it looks like this. And this little category here is the assets category, which leads you to this page. And we need to understand what your assets are when we do your estate plan, because we need to make sure that we give you the proper advice and we prepare the proper documents to transfer the assets over to the trust, for instance, or to advise you to update the beneficiaries accordingly. And so this asset is helpful in preparing your estate plan. But it's also helpful because even after we're done with your estate plan, what we do is encourage you to update these assets just to make sure that we do have an ongoing list of the assets that you own. And we don't anticipate anything happening to you anytime soon. And we really hope that we don't have to administer your estate. But we do want to be a tool, and we want to be able to help your loved ones carry out the administration. And so what we do is offer this this portal that you can update your assets and have a list with us. If anything were to happen, we have this list to start with to start marshaling your assets, taking inventory and appraising them. I know at Apriem as well, they're so good about having an understanding of all of their clients' assets. And I think that's really helpful to be able to help should, anything happen to their clients as well. So, you can make your own list. If you're working with us, this is the tool that we like to use. Okay, so we're talking about post-death administration. We're talking about what we can do to prepare now for that post-death administration. And a key to preparing for post-death administration is to make a list. Made a list of assets, and now we want to make a list of those debts and expenses, because again, in post-death administration, we need to make sure that we settle all legitimate claims. And trust me, people will come out of the woodworks to make sure that they get paid. And we want to have to sift, we don't want to sift through things wondering if they're legitimate. If you had a list of things that you pay on a regular basis, if you have loans that we talked about, credit card debt, that's helpful to have an understanding of. Practically speaking, it's also really helpful to have an understanding of what your common expenses are. Utility bills, homeowners associations, any of those things. And the reason for this is because these things still need to be paid during the administrative process. And we want to make sure that we have a list of what needs to be paid. If these things don't get paid, then all of a sudden your property, there's like a lien against your property, and then your beneficiaries who have an interest in this property are now upset because the value of their inheritance is going to be compromised. So we want to just make sure that we're keeping up with all the expenses that need to be paid during the administrative process. So having a list of debts and expenses will help facilitate that administration. Another list that we like to keep is one of contact information. And if you go back to our intake form here, that's another set of information that we do like to keep for our clients. We ask you to fill out any contact details, and that would include your heirs and beneficiaries, but we also ask about your advisors, because these are people who we're going to need to involve to do the post-death administration. So it's a team process. I'm just the attorney. If we have the accountant on hand, we have the financial advisor, that's also really helpful in administering your estate or your trust. And so the team doesn't usually include the attorney, and that may not just be an estate planning attorney. Your attorney, if you have a business, your business attorney is also invaluable in helping us get the proper documents to transfer your interest into, or to appraise your interest, or to know that you even have an interest. All of those documents are really helpful for us to assess what needs to be done and what your beneficiaries are entitled to. Another contact that we like to have on hand is your accountant, your CPA, people who have been preparing your tax returns. Those are kind of like clues for us when we're marshaling and inventorying your assets. We look at previous tax returns to see whether or not we're missing anything. So it's helpful to have your CPA also be part of our post-administration team. And so having a list with their contact information is also useful. If your financial advisors, when I do these trust administrations, financial advisors have been invaluable in helping me contact the banks, or just taking care of those assets that they manage. Also kind of reaching out to insurance companies to, take care of a lot of the administrative tasks there. So having your financial advisor be involved in the post-death administration is helpful. Preparing us with that list and the contact information for the people you work with would also be really helpful. Other people, life insurance agents, business partners, general partners, a lot of times people will have an interest in the business and we don't know who to call. So it'd be helpful to have a contact information for those, investments that you made with a limited partnership, for instance, so that we can make sure that's part of everything that's distributed to your beneficiaries. Okay, Also helpful to have a list of your heirs and your beneficiaries. We need to notify them by law. They need to be notified whether it's a probate administration or whether it's a trust administration. They need to know that someone has passed away and that they now have an interest in their estate or their trust. And we also need to, it would be helpful to have a list of your fiduciaries, the people that are part of your estate plan. Who's going to marshal those assets? Who do you trust to do that? Your trustees, your healthcare agents, all these people, it's helpful to have a list of so that we can contact them to facilitate the administration. Okay, so now that we understand what is involved in post-death administration, the key to preparing for it, making lists of all of the things that we have, the debts that we incur or the expenses we pay, and also contact information for the people that are involved in our, that we want involved and will help with the administration process. What should you do now? Well, hi, my name is Tiffany. I'm an estate planning attorney, and I typically try and help people prepare for post-death administration. So what I have to advise is to contact an estate planning attorney, and definitely doesn't have to be me. Really, when I meet new people and they find out that I'm an estate planning attorney, I'm happy to hear that they'll say, oh, well, I just got my trust done. And I'm very happy to hear that. You don't have to contact me. If you just have something done, I'm very happy to hear that you are doing that for your loved ones. But if you visit an estate planning attorney, what they're going to do is help prepare your administration process, the post-death administration, to make it as efficient as possible. So what I have here is, again, that list of those buckets, again, the diagram of the buckets. And if you were to visit me as an estate planning attorney, and probably others, what they're going to do is prepare documents for you, because, you know, we love paper. And so what we're going to do is give you a whole stack of paper, and they should often include those documents would include things that would facilitate the management of your assets if you pass away. So the administration process after you pass away. And bonus, you also get some documents that are going to help you in the event you're ever incapacitated. But for purposes of today's discussion, what we're going to talk about, or what's important, are all the documents, particularly the ones that would be prepared for you to facilitate administration upon your death. And what an estate planning attorney would prepare for you is, first of all, a trust. And the trust is under this trust bucket because, again, if it's titled, if your asset, your property, your bank account is titled in the trust, then it's going to be subject to the terms of this trust document, where a trustee is going to be facilitating the distribution of these assets to your beneficiaries. The second document an estate planning attorney should help you prepare is a will. And the will is over this probate bucket. And really, we don't want people to have to use their will, but we prepare it because inevitably a decedent will leave an asset in this probate bucket where it's just in that person's name. So just John Doe. And oftentimes this is a small account, like a checking account, but it's in John Doe's name and it doesn't have a beneficiary, which means it's in this bucket. And for assets that are in this bucket, again, that means that a court has to step in for the administration process. And then someone is charged, a personal representative is charged with marshaling inventory, appraising assets, and making sure they eventually go to the beneficiaries. But in this probate process, what happens is when it's subject to a probate proceeding, a court's going to ask whether or not the decedent died with a will. And if the decedent did die with a will, then the court is going to make sure the personal representative distributes the assets in this probate bucket to the people in your will. And if you had a trust, your will should say, if anything is in this bucket when I die, I want everything to go into my trust bucket. The third document an estate planning attorney should help you prepare is this general durable power of attorney. This is in the event of your incapacity. We want to make sure that assets are managed according to your wishes. And so you want to avoid a court process in doing that. So you appoint someone as your power of attorney to manage your assets. And then an estate planning attorney will also help you prepare healthcare documents to make sure someone can take care of or make your medical decisions in the event you can't do so yourself. Other helpful documents, maybe you just have some wishes that you want to memorialize in like a remembrance and services memorandum, where you just say, these are the people, if I know I'm going to pass away, these are the people I really want to visit me before I go. information that you might want in your eulogy. I mean, these are just helpful things that someone who is helping with the administration of your assets and preparing kind of the disposition of your remains, they just find it useful to have these documents in place too. Not totally necessary, just helpful. If you have a cemetery plot, just to have that handy, that purchase agreement for that plot. And I just encourage clients who do have those things prepared to put them all with their estate planning documents. What can you do to prepare now? I would highly suggest that you review the title of your assets. And again, those includes those documents, that the deed for your home, the statement for your bank accounts, those pink slips, the life insurance policy, share certificates, promissory notes, all of those evidences of ownership that will tell you how that asset is owned, what title it reflects. And we want to, again, make sure that it's not in this probate bucket. So if you want to prepare for administration, you want to make sure that you take a look at all of these evidences of title to make sure it's not in the probate bucket. That just makes it a lot easier after someone passes away. If we can avoid probate, that's really just the easiest path to go. The other thing you want to review are beneficiaries. So we have beneficiaries of life insurance policies, like beneficiaries of retirement plans. These are kind of just the most common assets that we have in this payable on death bucket. And if you put this on your asset list when you meet with us, then we're going to be able to advise you on who you should list as your beneficiaries. Generally speaking, your life insurance policy should have a primary beneficiary, and oftentimes the trust is an appropriate beneficiary to list as your primary beneficiary. Retirement plans, generally you want to list your spouse if you have one. That's just the most tax efficient beneficiary if you were to have one for your retirement plan. And your secondary beneficiary or your contingent beneficiary for your retirement plan is often your trust. Sometimes if you have adult children, it doesn't, you can just name your adult children, but review your beneficiaries, and super important to do so. One, you want to make sure you list beneficiaries and not just a primary person, like the primary beneficiary being a person. I've had situations where we list the primary beneficiary or someone's listed the primary beneficiary, but that person's already gone and we don't have a contingent beneficiary, which means now this asset has to go through probate. The other thing about beneficiaries that's really important is to not list minors. Minors do not have the legal capacity to own stuff. So they can't own a retirement account. They can't own a bank account to receive the life insurance policies. One of my very early matters when I was practicing was unfortunate situation where a firefighter had passed away, leaving his wife and a young daughter. I think she was 7 years old at the time. And the life insurance policy had 50% going to his wife and 50% going to his daughter. And unfortunately, that required a guardianship proceeding. Again, his 7-year-old daughter did not have the legal capacity to own a bank account even to receive her portion of the life insurance. So we had to ask a court to appoint her mom as the guardian of this account. And it could get complicated if we have to do an accounting every year to show how her mom might have used these proceeds for her benefit. So it's very important that we review your beneficiaries, that you have a beneficiary, and that you don't list minors as your beneficiary. So those are the things that we should do. Now, what should we not do? Let's not engage in do-it-yourself estate planning. I recently had a client and I was looking through his chain of title for his property. And I when I met him, I was like, there was a story to this chain of title. So what a chain of title is for a property is the list of owners from who one person is passing the property on to the next. And when I prepare for a consultation with my clients, I always look at their deeds to see whether or not they really do own their property in the way that they think they own it. And when I was looking at this particular piece of property, I saw that he eventually is the owner, but then before that, he was on title with his mom as a joint tenant. But before that, his mom owned it herself. And before that, she had it on her trust. And it was just a very complicated chain of title. And I asked him what happened. He said, unfortunately, as his mom got older, she was the victim of elder abuse. And someone had tried to contact her, tried to refinance her house, made her take it out of the trust. And so he engaged in kind of a little bit of estate planning on his own and added himself to title. And so it wasn't the worst idea. It also may not have been the best idea. There are some tax issues to do that that resulted from adding himself on title. There were also some income tax benefits that he lost out on by adding himself on title. So I would highly discourage you from doing estate planning on your own. There are ways of trying to avoid elder abuse, not necessarily adding yourself as joint tenant, perhaps, maybe adding yourself as a trustee. In any case, consult with an attorney to see what you can do to accomplish the goals that you're trying to accomplish. And in that case, it would have been to protect his mom from elder abuse. So no do-it-yourself planning. What should you not do? Don't procrastinate. No one knows when their last day is. So if you get all these things together, like I said, this webinar was not for people who are anticipating the loss of a loved one. Hopefully you can see that it really is meant for everybody. And if you don't have an estate plan in place, if you don't have those documents that I mentioned earlier, a trust, a will, power of attorney, healthcare documents, don't procrastinate. I've definitely been in situations where I'm either at the deathbed and trying to get things together. Just a few months ago, I'm just such a sucker for my clients. I got a call and she said her dad was literally on the deathbed, and I was writing documents at 10 o'clock at night when I got notified that he passed. And so all the effort that we put into trying to avoid probate was lost, and unfortunately he passed. And now his family has to go through a probate proceeding and do the administration through that more difficult process. So don't procrastinate. Do not plan. I just encourage you to plan. I mean, we know that there are two things that we can't avoid in life: death and taxes. Death is eventually going to come. We just want to make it as easy as possible for the people that we love, especially if you have children. God forbid anything happen while your children are young. I did have a client who did lose both of his parents when he was around 13, 14 years old. And what he told me is all he remembers of that period of time between 14 and 18 was being in and out of court with his aunt. It was terrible. It was a sad experience to even have to listen to. And so don't not plan. Make sure you have some documents in place to help, to take care of your loved ones if you were to pass, or when you pass. Some practical tips. Okay, I know earlier I said don't add yourself as joint tenant, but what I mean is when it might be practical to add yourself as a joint tenant to like a checking account, a small checking account. Once something happens to somebody, if they pass away, the account is basically frozen, and you can't use that person's money to even pay for their expenses. So if you add someone to a small joint checking account, it's helpful to ease that transition between someone passing away and someone having to take care of all those expenses, like that HOA, your property taxes, your utility bills, all those things. If you could just add someone as a joint tenant to that account, that person can take over if anything happens to somebody or the other joint tenant. Another practical tip is having a family meeting. I have a client right now who knows that she's going to pass away soon, and she's doing everything she can in this pre-death circumstance right now to plan. And what we're preparing for is a family meeting with her children. And we just want to make sure that they understand what's happening. They understand what her wishes are, especially, and this is not the case with this client, but especially if you have an uneven distribution of assets, it's really helpful to sit down with your family and explain why you have it that way so that we can avoid litigation or contention post-death. So I would suggest a family meeting. And I think that pretty much wraps it up. So any questions? I see question is, can the contents of a trust or will be contested in court by a sibling who feels they were excluded? And if so, is there anything we can do to prevent the chance they can successfully challenge it? So yes, this estate plan, people come in and their goal is to make sure that no one contests their documents and the way that they want their assets distributed. I can't stop someone from contesting, but the fact that you're in my office ready to write everything down is already one step towards avoiding a contest. So what I'm saying is, no, there is really no way of absolutely avoiding, guaranteeing that no one is going to contest your wishes in your testamentary documents, like your trust or your will. But what you can do to prevent that is to include clauses to basically say, hey, I know everything that is in this trust. I understand the way that I've laid it out, and if anyone contests the terms of my trust or my will, then they don't receive anything, which would really discourage anyone from trying to contest if they're trying to if they're looking to get anything from your estate or your trust. The next question is, if all liquid assets are in a payable on death or beneficiary designation, how are claims paid? So this actually is an interesting question, because I had a friend that I was talking to recently, and she was in a situation, or part of a situation, where she knew someone who wanted to do the right thing, and their dad passed away. So two brothers, brother is here, the other brother is out of the country, and dad passed away. Brother that's in the US was trying to take care of everything and do the right thing. And so basically he immediately split all the assets in 50-50 and sent it over to his other brother, and not knowing that there are all these claims that need to be paid. What ended up happening is the other brother would not pay him back for all these expenses that he had to incur on behalf of his dad. And he asked what they can do, and basically nothing. Unfortunately, they also later on found out that they had a checking account, and there were payable on death beneficiaries, and we can't get the bank to not pay the beneficiaries that are listed with the bank. We can't have it go to, for instance, the brother that was paying all the expenses to pay him back. The bank is just going to make a check out to the beneficiaries that were listed. So your questions, how are these claims paid? They're going to be paid through a probate estate if they're not going to be paid, initiating payment to of these credit card claims or debts. Hope I answered that question. Should my trust include my IRA? No. If you recall those buckets, there were 4 of them. And the first bucket's the trust bucket. The second one's the payable on death. The third is the joint tenancy. And the last one's the probate bucket. Your IRA should be in that payable on death bucket. So that means that it's not titled in your trust, it's titled in your name, but it's in that payable on death bucket versus the probate bucket, because you listed a beneficiary on that particular account. So your IRA should not be in the trust. Your trust might be a beneficiary of that account, but it's not going to be the owner of that IRA. Assuming that you have designated the trust as the beneficiary for all assets already, but one sibling was not listed as a trust or executor. Oh, I think that was a follow-up to the previous question about a sibling being able to contest the terms of a trust. Yeah, if they're already designated as a beneficiary, then if they're not the trustee or executor, the trustee or executor is going to have to do an accounting to this sibling. So at least they're going to have be notified of the administration. Okay, why not put bank accounts in payable on death instead of trust? That's a great question. So someone is asking, why not put my bank account? Why not just list a beneficiary for my bank account? Why do I need to put it into the trust? I would say generally you want to put accounts to the extent possible into the trust. And that's just a practical reason. And that is because if you just have an asset that's in your own name and you list a beneficiary, so it's not in the probate bucket, you just list a beneficiary on it. What that means is that in the event of your incapacity, your power of attorney is going to have to rely on that document called the general durable power of attorney in order to manage this particular asset for you. So this is not so much an issue in the event of death. It's an issue in the event of incapacity. So if you leave a bank account in that payable on death bucket with the beneficiary, if you're incapacitated, your agent, your power of attorney has to use that general durable power of attorney. Legally speaking, it's enforceable. Practically speaking, banks don't like old ones. And I don't often have clients who update their trusts and their estate planning documents every 3 to 5 years, but that's how often banks that's how recent a bank wants to see a power of attorney. By contrast, if you were to put that account into a trust, then in the event of your incapacity, they rely on the trust document to see who is allowed to manage it on your behalf. And the trust document, the banks usually don't care if the trust document is 20 years old. They'll let the successor trustee step in and manage it for you. So why not put bank accounts into the payable on death bucket instead of the trust bucket? It's just a practical matter. Banks just don't like old powers of attorney. So your question is, if 2 people are not married, but they own property as joint tenants, what happens to the cost basis of the property on the death of one of the joint tenants? And what happens to the real estate taxes? So there is a benefit to being married, especially in California, where we are a community property state. if you owned a property as community property and one of you passes away, a spouse passes away, you get a complete step up in basis. I don't know if we really have the time to discuss what that means, but it seems like this person asking the question understands what that means. By contrast, if you're not married and one of the joint tenants passes away, you only get a step up in basis in half the property, assuming they only own 50% of the property. What happens to real estate taxes? Well, if real estate taxes, that's a complicated question, but if you're that 50%, and it's a complicated question because property taxes for joint tenants is very complicated, but if if you're passing the general rule is if you're passing real estate to someone, you have an opportunity to get reassessed if it's not under an exemption, and passing it to a partner is not under an exemption. So you might get reassessed on 50% of the property. If all assets are either in joint tenancy or payable on death, would an estate go through probate? Generally speaking, no. I just hesitate to make such definitive answers because all of my answers should end in it depends. But generally speaking, if it's in the payable on death bucket, it shouldn't have to go through probate. I say that with some hesitation because what if all your beneficiaries passed away? Then it would end up in probate. What if all your joint tenants passed away? It would end up in probate. Okay, if a parent has no assets, who is responsible to pay for their debts? If they have no assets, then their debts are extinguished in probate. Like you usually have to try to negotiate debts, but if there's no assets in the estate to pay them, then they can't get paid. See, my trust was prepared about 6 years ago. How often should the trust be reviewed and or updated? If you visit my website, chiulaw.com, I do have a link called blog. And if you scroll down, there's a post about when you should take a look at your trust and your estate planning documents. Generally speaking, take a look at them every 3 to 5 years. There are life changes that might require you to look at your estate planning documents sooner than that. So if you want to take a look at that particular post, that's what we're trying to address. And what are some common questions you get regarding this process? Wow. All these questions that I've gotten so far are not uncommon. And let's see, I don't know, I get a lot of questions. A lot of the questions do have to do with people's debts and hoping that they don't have to take care of someone else's debt. That's pretty much it.
Is that all the questions?
That's all the questions I have here.
Perfect timing.
Oh, great.
Because that brings us right to about
sweet.
2 o'clock. So
2 o'clock.
I'm going to go ahead and we will step in here. I'm going to close this down. All right. And with that, first, we just want to thank everybody for joining us today. I hope that you enjoyed Tiffany as much as we always do. With that, we wish you all a very happy holidays and we'll see you next year.